I think this was everyone that had previously been referred to the National Anti-Corruption Commission over Robodebt last week.
Just when I thought I was out, they pulled me back in.
That bombshell this morning into Australia's Robodebt corruption probe.
Davina, the National Anti-Corruption Commission has just announced it will reconsider its decision not to investigate referrals from the Robodebt Royal Commission.
If nothing else, I'm a sucker for a bombshell news story.
Bombshell. Bombshell? Bombshell.
Bombshell!
On the 30th of October, the Inspector of the National Anti-Corruption Commission released their report on the NACC's decision not to investigate the referrals from the Royal Commission into the Robodebt scheme. Look, I know I can be a bit of a cynic, but honestly, when I put out that last Robodebt video in September, I thought that'd probably be the end of the whole sorry saga. The likelihood of the Royal Commission referrals ever being investigated by the National Anti-Corruption Commission seemed remote at best. But maybe I was a little too hasty on that one. It's really hard to think of an institution that has managed to do so much damage to its reputation in such a short period of time. The fact that the NACC has not delivered anything of substance just adds insult to injury. Anyway, the short version of this bombshell report. The report outlines the findings of the Inspector of the NACC's investigation into the decision of the NACC not to investigate referrals of 6 persons from the Royal Commission into the Robodebt scheme. The focus was on the actions of the NACC Commissioner, Paul Brereton, following his declaration of a conflict of interest in relation to one of the people referred by the Royal Commission to the NACC. The inspector found that the NACC Commissioner had made a number of declarations of his potential conflict of interest in relation to a person that the Commissioner said he knows well, who is well known to me, and with whom I have had a close association. This person, a senior public servant, is referred to throughout the report as Referred Person 1. At this point, it's important to remember that the names of those referred to the NACC by the Royal Commission are included in the sealed section of the Royal Commission report. So we can really only speculate as to who the referred persons are. That is, I guess, until the sealed section is unsealed.
And now for something completely different.
Now, totally unrelated, of course, but I took a look at the main players involved in the Robodebt shambles in a previous video. Here's a quick walk down memory lane and a look at one of those people.
Flashback.
Then there was Catherine Campbell, a public servant, not a politician, but as the Royal Commission found, Campbell was responsible for a department that had established, implemented and maintained an unlawful program. The Royal Commission report said that when exposed to information that brought to light the illegality of the program, she did nothing of substance. When presented with opportunities to obtain advice on the lawfulness of the practice, she failed to act. Campbell would eventually be suspended without pay from her roughly $900,000 a year government job before going on to resign in 2023. But justice? Campbell didn't just survive the early Robodebt fallout in 2017, she prospered. In 2017, she was promoted to lead the Department of Social Services, before moving on to Foreign Affairs and Trade. Granted, she was dumped by Labor when they took office, but she was quickly parachuted back into a $900,000 a year job on AUKUS with the Department of Defence. I'd hazard a guess that in the 6 or so years between 2017 and her eventual resignation, she earned around the same amount of money as someone on the average wage would collect over a 40-year career. And who knows whether or not she retained the lucrative sounding pension.
Back in present day.
In what would have to be an odd coincidence, if you do a Google image search of Catherine Campbell and Robodebt, you don't have to scroll too far before you start seeing images of her with the current NACC Commissioner. Anyway, back to the video. The NACC Commissioner dealt with his conflict of interest by delegating the decision about whether or not to investigate the referrals to his deputy. The inspector found that in light of the NACC Commissioner's conflict of interest, Brereton should have not only designated a delegate but also removed himself from all related decision-making processes and limited his exposure to relevant factual information. The inspector found that this was not done. It gets worse for Brereton. The inspector went on to find that the NACC Commissioner's involvement in decision-making was comprehensive before, during and after the 19th of October 2023 meeting at which the decision was made not to investigate the Royal Commission's referral. When it comes to that 19th of October meeting, the minutes note that the Commissioner stated that a second inquiry into the matters would not appear to add value in the public interest. Even more puzzling, the minutes note that the Commissioner stated that all the Commission could do was make a finding that there was corrupt conduct and that he could not see where the Commission could add value. I'm sorry, but isn't investigating corrupt conduct kind of the job you signed up for? The inspector found that the NACC Commissioner contributed to discussions at that meeting, settled the minutes of that meeting, and was involved in formulating the reasons for the decision and also the terms of the media statement. The inspector concluded that a third-party, fair-minded observer might reasonably apprehend that the NACC Commissioner's involvement might have impugned on the impartiality of the decision-making of the delegated Deputy Commissioner. It should be noted that the inspector made no findings against the Deputy Commissioner. The inspector found that justice and procedural fairness required that Brereton remove himself from any decision-making. The inspector concluded that the NACC Commissioner engaged in officer misconduct as defined in Section 184, Section 3 of the National Anti-Corruption Commission Act 2022, being conduct that is not unlawful but arose from a mistake of law or fact. The inspector finally recommended that the Commissioner delegate their function to reconsider whether or how to deal with a corruption issue, namely referrals from the Royal Commission into the Robodebt scheme, to an appropriate person. The NACC has since accepted that finding. So in essence, now someone else is going to come in and review the Royal Commission's referrals and reconsider how they are dealt with. So in terms of Robodebt and justice...
So you're telling me there's a chance?
I guess we'll just have to wait and see. Even the NACC's media statement that appeared to take months and months to draft drew the attention of the NACC inspector, who found that the NACC made a misleading statement in its own media release. The release said that the Australian Public Service Commission had remedial power and could impose a sanction in relation to the persons referred. This wasn't true. The APSC can only impose a sanction on a current public servant. 5 of the 6 people referred were no longer public servants, and the 6th was never a public servant.
The media statement itself that was put out to explain this decision is part of the problem here, because it contained, according to the inspector and Alan Robertson, the former federal court judge, it contained misleading statements. You know, they said, we don't want to duplicate processes, and the Australian Public Service Commission is looking into this, and they've got sanctions they can attach. But none of the people, or very few of the people that were referred to the NACC, who were also being looked into by the Public Service Commission, would ever have attracted sanctions because they were former public servants. And so that was misleading, and it was misleading as well to say that, you know, there wasn't anything they could do, and that, you know, a minister who was referred to them could also be found, you know, accountable to the Public Service Commission. So there are these real gaping holes in their rationale. The reasoning was specious.
It kind of gets worse. The people that had been referred to the NACC by the Royal Commission were then given the opportunity to comment on the NACC's proposed public statement of its decision. A lawyer, on behalf of the person with whom the Commissioner had declared his conflict of interest, provided proposed amendments, which the Commissioner then accepted. These amendments softened the language within the statement a little bit. Look, this report does not make for pretty reading for Brereton, and you'd have to say at this stage his position is untenable. Officer misconduct, albeit not unlawful, is misconduct all the same. Declaring a conflict of interest is one thing, but it's another thing entirely to declare a conflict of interest and then be found to have been comprehensively involved in the decision-making process. The fair-minded observer would have to think that it's only a matter of time before he hands in his letter of resignation. It's the obvious question: how can the Commissioner of the NACC continue in that position, having been found to have committed officer misconduct on the NACC's first big-ticket public assignment? Members of the crossbench have already spoken out publicly. First, there's David Pocock, who I reckon is fast becoming Australia's political conscience on ABC's 7:30.
Given what's happened and the Commissioner not properly recusing himself, the NACC has to, the Commissioner of the NACC has to, their integrity has to be beyond reproach. And I'm very concerned that after these findings, that is very much in doubt, and we have to put trust in the NACC and this institution front and centre. And I think it's been a pretty patchy start.
Should the Commissioner step down?
I think given the need to ensure that there is trust in the NACC, given these findings, I think his position is untenable. But that's ultimately a decision for him, and I'd be urging him to do what is best for the NACC and people's trust in that institution. It's one thing to say I have a conflict of interest, but then to sit in those meetings and be involved in discussions to the point of being involved in how you're framing the media release, that really doesn't seem to cut it with what Australians would expect of something that should be, beyond reproach, the National Anti-Corruption Commission.
Then there was Green Senator David Shoebridge.
Commissioner Brereton should ask himself whether him remaining in that position is good for the National Anti-Corruption Commission and whether or not that engenders public confidence in the National Anti-Corruption Commission, because these findings are utterly damning. And in fact, when you read Inspector Furness's report, and then you read the attachments and the materials she relied upon, it only becomes more damning for Commissioner Brereton, because his initial submission, on behalf of the Commission to the NACC Inspector was there was nothing to see, that he'd acted entirely appropriately, and that there should be no criticism. And it was only when he was absolutely pressed by the Inspector that eventually conceded reluctantly that actually perhaps there was a conflict of interest which he didn't handle properly. But the question is, can you have the Commissioner of the NACC in its single most high-profile decision be found to have engaged in officer misconduct, found to have failed to deal with a very, very clear conflict of interest? And can he retain the confidence of the Parliament? Can he retain the confidence of the public? I think that's a question Commissioner Brereton should be asking himself. And in fact, the more you look at the material that was supplied and has now been uncovered in this inspector's report, the more troubling it gets. At one point, we have Commissioner Brereton seeking legal advice about the Robodebt and suggesting to the lawyers that perhaps having public servants deliberately act unlawfully in order to implement the will of the government, he's suggesting that whether or not that's corruption or not would be a novel concept, and questioning whether or not that could actually amount to corruption. Now, that was at the heart of the Robodebt inquiry. And sure. I find the actions of the Commissioner here really do cast a totally unnecessary, a totally inappropriate pall over the National Anti-Corruption Commission that, as a Green Senator, I want to see work. It's hard to see how anyone can have full confidence in the National Anti-Corruption Commission when the person in charge of it, on the single most high-profile inquiry that it's done to date, a matter of genuine national angst, made such a terrible error. And then, even when it was pointed out to him, pressed on with it and couldn't see a problem with it in the submissions that he made to the Inspector. I think that's a very, very troubling place for the Commission to be put in.
For the government, the Inspector's report apparently is evidence that the system is working, or that the NACC's own oversight body is anyway. I think it's well worth noting that it was amendments from the Greens that strengthened the powers of the NACC Inspector, amendments that Labor pushed back on. That's important to recognise when you have the government pointing to the work of the NACC Inspector as evidence that the system is working. And from the opposition, all they have is a conspiracy theory as to the timing of the report's release. I reckon that if the NACC has any chance of redeeming itself, Brereton needs to go, but to be perfectly blunt, Mark Dreyfus should go with him.
As the inaugural Commissioner of the National Anti-Corruption Commission, I will be nominating to the Governor-General one of Australia's most respected and highly qualified investigators, Justice Paul Brereton.
As architect of the NACC, he has been key in delivering what's clearly a toothless tiger. Add to that his handling of whistleblowers, and it's hard to give the Attorney-General a pass mark. The NACC so far has been an abject failure, unable to meet one of the core objectives set out for it by the federal government, and that was to restore public trust. You could argue that it was doomed to fail from its inception, the exceptional circumstances clause to limit public hearings, through to the refusal to look at pork barrelling. None of that passed the famous pub test. If you did want to set up an institution to stamp out political corruption and restore public confidence in governments and politicians, I don't reckon you'd want to be using the NACC as a template.